Infringement of copyright is a serious legal issue. So today we'll learn about it in detail. Now, copyright is one of the intellectual property right which can be claimed over six kind of works. That is literary work, artistic work, dramatic work, musical work, cinematograph films, and sound recording. The key aspect of copyright is infringement of copyright. Now, the term infringement means unauthorized or illegal use of someone else's work on which that person is claiming a copyright. That is called infringement of copyright. So, if you are using someone else's work without permission or without taking license from the appropriate authority or from that person, in that case, it will amount to infringement of copyright. Now, infringement are of two types under the Copyright Act, that is primary infringement and secondary infringement. Primary infringement occurs when a person uses or reproduces the work of someone else without taking license from the copyright holder or from the appropriate authority, then it is called primary infringement. It also occurs if a person has a license but uses or reproduces the work in contravention of the terms and conditions of the license. Even in that case, it is called infringement of copyright. For example, if I have written a book in English on the topic of arrest, in that case, I have a copyright over that book. Now, if someone else, without taking license from me, translate that book into Hindi, then it amounts to infringement of copyright because translation of work is also my copyright. Now, if I have given a license to the person to translate that book into Hindi, but he also translates that book into Punjabi, even then it amounts to infringement of copyright because now he uses my work in infringement or in contravention of the provisions of the license, because under license only the translation in Hindi was allowed and not in any other language. So it also amounts to infringement of copyright. The second form of infringement is secondary infringement. Now, in this, the infringement does not occur directly. It means you are not using or reproducing the work. But if you are allowing others to use your place for communication of the work, which is the infringement of copyright, in that case, it also amounts to infringement and you can be liable for that. For example, if I have a hotel and I allow my hotel to showcase a movie, but the movie which is shown in my hotel is a pirated movie. In that case, even I would be liable for the infringement of copyright because I allow my place to be used for communication of work which is an infringement of copyright. But if I am not aware that the work which is communicated at my place is an infringement of copyright, then I would not be liable for infringement of copyright. So, awareness about the infringement of copyright is a key essential to make a person liable for secondary infringement. The other forms of secondary infringement is if you are selling or hiring an infringed copy, then also it amounts to infringement. Secondly, you are distributing an infringed copy. Now here you are not getting any amount, but you are merely distributing an infringed copy, then also it amounts to infringement of copyright. For example, if I make a photocopy of a renowned author of a book or a novel and distributing it to the public, then it amounts to infringement of copyright. Third is the exhibiting any infringed work also amounts to infringement of copyright. So, if I display or if I am exhibiting a movie which is a pirated movie, now here also now the exhibition of work also amounts to infringement of copyright, irrespective of the fact that I am earning something from that exhibition. The fourth form of secondary infringement is importing infringed copy from outside India into India. But there is one exception to it, that if you are carrying any infringed copy for a private or domestic use and the number of copy is 1, in that case you cannot be made liable for infringement of copyright. Now, we are using time and again the term infringed copy. This term is defined under Section 2M of the Copyright Act 1957. which means in case of literary, artistic, musical, and dramatic work, if the work is reproduced in any form, then it is called infringing copy. So, if I have written a book and someone else made a copy of it, then the copy which that person made is called infringing copy. Secondly, if I have written any poem or poetry and someone else made a song of it without my permission, even that song will amount to infringing copy. Secondly, in case of cinematograph films, if anyone makes copy of that movie, to which we in general language call pirated copy, will amount to infringing copy. With regard to sound recording, if someone uses that sound recording in another work or make a copy of it, then that copy or that piece of work which contains that sound recording will amount to infringing copy. And with regard to broadcast programs, if someone else records that program without permission, then it also amounts to infringing. Now, next we will talk about the test to determine infringement of copyright. Though there is no parameter laid down in the Act itself to determine whether any work is an infringement of copyright or not. But the Supreme Court, in the case of R.G. Anand versus Deluxe Film, 1978 Supreme Court has laid down the parameters by which we can determine whether any work is infringed or not. The test laid down by the Supreme Court is, firstly, that there is no copyright exists in case of any idea, subject matter, or historical facts. So, the first step the Supreme Court lays down that there is no copyright exists in subject matter, any idea, or historical facts. The copyright exists in the expression of that idea or the execution of subject matter or historical facts. Now, if we take the example of it, we have seen number of films made on the life of Bhagat Singh, Mahatma Gandhi, Subhash Chandra Bose, and others. Now, if we look at those movies, the main storyline remains the same, but no work amounts to infringement of copyright of the other. The reason being that all the movies are made on historical facts and no person owns any copyright over those historical facts. And if we talk about the execution, then the execution in all the movies is different. That's why it does not amount to copyright infringement. Now we are talking about that number of works are made on a single subject matter or on a single historical fact. In that case, similarities are bound to occur. But the Supreme Court says that we have to see that whether there are mere similarities or the substantial part of the work is copied. It means that a major part of the work is an imitation of the other work. Now, how we will find whether it is a substantial copy or there is mere similarity occurring due to the fact that it is based on the same topic. With regard to determination of substantial similarity, the court lays down the third rule, which says that the public at large or the spectators or readers of the work will determine that after reading or seeing that work, whether they feel that it is an imitation of the previous work or not. If the answer is yes, then the relevant work will be considered as an infringement of copyright. So, fourthly, the court lays down that if the idea or the concept is same but the execution of that idea or subject matter is different, in that case there is no case of infringement of copyright. So these are the parameters which we need to keep in mind while determining whether there is an infringement of copyright or not. Now the next concept is remedies against the infringement of copyright. There is a Latin maxim which says ubi jus ibi remedium, which means wherever there is a violation of right, there is a remedy. Now, the Copyright Act not only provides the protection of copyright but also provides remedies in case of infringement of copyright. The Copyright Act mainly provides two types of remedies, civil remedies and criminal remedies. Now, the first is civil remedies, which are covered under section 54 to 62 of the Copyright Act 1957. Now, the first remedy which the aggrieved party can avail is injunction, which means to stay the action. Now, if the person is using the or reproducing the copyrighted work, then the aggrieved party can move to the court and take injunction, which will prevent the other party from using or reproducing that work. Now, injunction can be of two types: temporary injunction and permanent injunction. Temporary injunction is the one which is taken during the hearing of the case till the final disposal of the case. And if the person found guilty, in that case, permanent injunction is issued against that person to stop that person from using or reproducing that work in future. The second remedy is to take damages. Now, when someone else uses your work, you also face financial loss. Now, to recover that loss, a person can take a remedy of damages in which the court will calculate your loss and will grant you the amount as damages. The third relief is account for profit. Under this also a person takes monetary relief. But the difference between damages and account for profit is that in case of damages, a person takes the money for the loss which he has suffered due to the infringement. Whereas in case of account for profit, a case occurs where the defendant not only infringed the copyright but has also converted that work into another form and earns profit. Now, in that case, the plaintiff can ask for the profit which the defendant has earned due to the conversion of the copyrighted work into another form. That is called account for profit. Fourth remedy is the search and seizure. In this case, the plaintiff can ask the court to issue order for search and seizure. In this, the premises are searched, and if any infringing copies are found in that premises, then those copies are seized by the court. Now, these are the four major remedies which a plaintiff can take against the defendant. But if during the case it is found that the defendant was not aware that he is making infringement or someone else copyright, in that case the plaintiff can take only one remedy against the defendant, that is injunction, that is to prevent the defendant from using the copyrighted work in future. With regard to the jurisdiction, then the case of the infringement of copyright can be filed in the district. And if we talk about the territorial jurisdiction, then the person can file a case in a court where he resides, or if there are more than one copyright holder, where any one of them resides or personally works for gain or carries out any business. Now, this rule is different from the CPC rules because under CPC, we file a case where the defendant resides or works for gain or carries out business. This is the major difference between CPC and the Copyright Act 1957 with regard to the territorial limits. The limitation period for filing the infringement of copyright is 3 years. Now the next is criminal remedies. The Copyright Act 1957 does not prescribe only the civil remedies but also make the act of infringement of copyright an offense. So, if the person knowingly infringing someone else's work or abetting infringement, then the act is punishable under section 63 of the Copyright Act, and the punishment for it is minimum imprisonment is 6 months and maximum imprisonment which can be given by the court is 3 years, and fine which is minimum 50,000 and maximum 2 lakhs. The third act which is made punishable under the act is knowingly using the infringed copies of computer program. Now it is punishable under section 63B. Here the imprisonment is minimum 7 days and maximum 3 years. Along with imprisonment, the court imposes fine which is minimum 50,000 and maximum 2 lakh. So this is all about the infringement of copyright. There are also exceptions under which the act will not amount to infringement of copyright. Those exceptions will be covered under different video. I hope you like the video. For more such videos, please like, share and subscribe.